All of that ice cream.
Welcome to the House Environment Committee. We're going to continue walking through draft 1.2 of S 325. We have two representatives from the Land Use Review Board here with us now. And we were previously discussing a new section 8 that we added to have kind of reconsideration of an application rather than going back to the district coordinator or that district commission, go to the Land Use Review Board. And then we started talking about JOs and whether they should do the same. And then Ellen reminded us there are rules for that. So I guess I'm curious if you have comments or suggestions.
Sure.
Sure. I'm Brooke Dingledine. I'm a member of the Land Use Review Board. So reconsiderations of either jurisdictional opinions, to go back normally to the district coordinator, the same person. And it is fashioned off of the court rules when a tribunal makes a decision if some fundamental mistake, either understanding the law or applying it to the facts that's obviously erroneous has occurred. It's an opportunity to point that out before an appeal is taken to try to correct an obvious mistake at that level. Normally it goes back to the original decision maker. I don't believe that on denials there's any reconsideration available district to ask the district commission to do such a thing.
On jurisdictional opinions.
On denials of permits.
Permits.
Right.
Yeah, there is actually.
There is.
Oh,
Yeah.
there's
That's what we're
certainly.
looking at amending in statute.
Okay, that's the provision, I guess, that I was not familiar with, so we were just listening to this conversation. My only point about it is reconsideration is a fairly limited, it's an erroneous, there's a mistake been made. And if you were contemplating having a hearing by the Land Use Review Board, that would suggest taking evidence or looking at the evidence and making perhaps a substantive decision, a different decision, or looking at the facts and applying the law to come to another conclusion. It may be the same conclusion. So those are just two different processes or requests. And just wanted to be sure that there was an understanding of what exactly you were asking the Land Use Review Board to do.
Yeah, thank you for that. It's very helpful. I think this may fall into the bucket of we should not meddle right now in this. We'll let it be and trust that we know you all at your earliest convenience are going to be updating your rules to reflect the changes that have happened. Representative Chapin.
So I'd just love to take a moment and let the committee know that I've been keeping a running list of sort of parking lot issues around Act 180 that we're probably not going to deal with this year, but that people are raising just because we've gotten so much great feedback and testimony and so many different thoughts. And I just wanted to share that I'm just doing that, and I'd be happy to share it at some point. I'm going to add this one to the list.
So,
Representative Leader.
based on your comment, does that mean that the new section 8 is actually going to be stricken or?
Yeah, I think we
Just
should
so I
get out.
understand. Okay.
I don't know, we're taking it out.
Taking it out. This falls under, this would need a lot of consideration, and maybe there's something there, but it's not focused right now.
And the next section 9 is the one where how municipal 1A municipalities would take over Act 250 permits, right?
Yes.
And was the lawyer part of that testimony in the Senate?
Section 9,
Myself, yeah.
Oh,
page 8 and 9.
So, yes, this is, yeah, Pete Gill, Executive Director of the Land Use Review Board. This section is dealing with, Tier 1A and the, enforcement of those, permits and the transfer of that. So we were part of the discussion on that, yes.
Chair.
This is not the wording that we provided, but, we were part of that section.
I don't know, the big concern that I think that we had and towns had was taking all of Act 250.
We understand the concern,
Okay, so.
all of it all at once,
Right.
right? This would allow for more incremental. Yeah, okay.
All right, and so that language hasn't changed as it came over from the Senate. And so the next on page 10, section 10 is new. This is amending Act 181, section 34, which is a report currently entitled Tier 2 Area Report. But given that you're getting rid of Tier 2 in this draft, you have options on what you want to do with this report. Currently in the provision, it still says that it's due February 15th, 2026, which has already passed. But you can consider extending that, especially if you're going to be changing in some way what you want them to look at in this report. And so as a sort of proposal on what to call the report, you can talk about this, but on page 10, line 9, tools to promote intact working lands and conservation of critical natural resources area or critical natural resources report. And so, yes, it still says February 15th, 2026, the Land Use Review Board shall report recommendations to address Act 250 jurisdiction in areas without municipal delegation of Act 250 review.
So, I'm gonna go back to y'all. The other day, we invited Willard in to talk about the Tier 2 report, but I'm not sure, have you all started it? Have you started the Tier 2 report?
I don't believe that the report has been started. The AOSB portion of it, there was work done on that. But it became apparent all of these were so intermingled that we felt we really needed to get to that chronologically later after the other tier work was further along, especially tier 3. We were trying to do many different tests.
Yes. It wasn't, yeah, I just was curious. Okay. Anyway, I think this section will also require some fine tuning, which I'm happy to take the lead on, but I also want to just keep walking through it.
Right, so you have the option to change as much or as little of this as you'd like. There are a couple of references to Tier 2, but the rest of it is talking about the different aspects of working lands and jurisdiction. So line 14, and you were talking last week about perhaps Tier 1 will be called municipal delegated areas, or so I have added that reference here.
And actually, I don't want to call them out separately. So it was
Yeah.
never our intent to not protect critical resources in areas with delegation. That was never the intent of what we were doing. Clarify that. For example, the issue, and further, the issue of ag lands and other things. So I think we need to rename things, move away from tiers and not treat our natural resources differently based on where they are.
So the recommendation shall recommend statutory to address fragmentation of rural and working lands while allowing for development. Address how to apply location-based jurisdiction to, and it says currently Tier 2 areas, but striking that while, how to apply location-based jurisdiction while meeting statewide planning goals, including how to address commercial development. So I'll pause there for a second. So that was my recommendation on line 17 about striking a reference to tier 2. I think the sentence works without it, but you also can rework it in a different way to accomplish whatever you'd like them to be looking at specifically.
Representative Nor.
Yes, Madam Chair, again, given your comment about, regardless of where the natural resources are, we're going to particularly, do we really want line 13 and 14, that yellow, without municipal delegation of activity review? I mean, should this report just cover the entire state?
Yes, it should.
Okay, so we're going to delete that yellow.
Yeah. Yeah, I mean, I think it's gonna get kind of entirely rewritten, right? So, like, I made a stab at the title for the report, and it's not intended to just be focused on Act 250 as the tool. So it's like collecting other ways of addressing the issue.
Right, the bigger thing we've been talking about.
Representative Tagliavia.
Line 18, meetings, should the S be taken out?
Oh, sure. All right, so at the bottom of page 10 into page 11, so including how to address commercial development, and which also shall include review of the effectiveness of mitigation of impacts on primary agricultural soils and making recommendations for how to improve protections for this natural resource. Review of the effectiveness of jurisdictional triggers for development of retail and service businesses outside village centers. And criterion 9L in addressing sprawl and strip development and how to improve the effectiveness of criterion 9L. And review of whether and how Act 250 jurisdiction over commercial activities on farms should be revised, including accessory on-farm businesses. The report shall be submitted to House Committee on Agriculture and this committee, although we can update the name of it. And then the Senate Committee on Agriculture and Natural Resources. And then at the end, subsection C, I've added subsection C, which is the list of stakeholders to be involved in the tier 3 rulemaking process. Because you discussed last week that the large, input of the stakeholders there. So I wasn't sure if you wanted to keep all of them or how you wanted to frame it, but currently this report does not have a stakeholder explicit process.
Right. And just to clarify with the Brooke and Peter, are you saying you feel like you've already done the accessory on-farm business report?
We have started work on it and
There was not a working group on it. We did have a working group on it previously, and we authored a report that was issued years ago, I think now. So there is a lot of good information in that. There's probably still some language out there that could be revised or relooked at in the context of this.
I thought we exempted this accessory farm.
So yes, there is an exemption in Act 250 currently for some accessory on-farm businesses.
Okay. So what is this referring to?
They want more.
Yeah, okay.
There's a explicit, if I may, there's a explicit provision that does not, for our exemption, that does not include events on farms. So that has been an area that has come up.
And I do think that there is in one bill that's circulating, in addition to a business being able to sell a certain amount, I think it's $250,000 worth of non-qualifying goods, so non-farm products. Whereas currently, the touchstone is whether or not more than 50% of the products that are sold are the qualifying farm.
Which previously was satisfactory. Many farmers.
And the Lord's testimony on that particular item was our preference that because we are working on this and trying to prefer not to have something come into law temporarily or to allow us to do the work to make the recommendations.
Yeah. Representative Richard.
What would be the downside to lowering that to make it work for? I mean, what's the downside of decreasing that number?
Representative Chapin.
So there's a huge diversity of kinds of the concept of accessory on-farm businesses includes everything from like farm stands to wedding venues and restaurants and things that do involve a lot of impact on the rest of the neighbors and other parts of town and the roads. So a lot of neighbors and municipalities aren't comfortable with extending no land use provisions over certain kinds of larger scale activities. So traffic, noise, a lot of things that are covered in zoning and Act 250 kinds of. And there's a real diversity of opinion within the agricultural community, within the land conservation community, within the municipal communities about where that line should fall. So it just really depends on who you ask and how impactful it is to somebody's financial bottom line. It's, you could open a wedding venue on a farm and do it with permits and get those permits and make it work. And for some people, either they feel like they can't go through that process, or they won't go through that process, or neighbors won't make it easy for them to go through that process. So there's just a lot of challenges, and it's really unique in every different situation.
And interestingly, it gets to the acreage trigger, right? So it's a commercial. What happens is a lot of farms, legit farms, they have a lot of acreage. So they're even in a 10-acre town, if they want to do a commercial activity, any other business would have to get a regular permit, right? But that's why it's very important, because we provide a lot of exemptions for agriculture, including to Act 250. But the difference between was it a farm? Is it a business to support a farm? Or is it a farm to support a business? It's kind of what we kind of always struggling to define. Representative.
In my area, there's several farms that are well diversified, wedding venues, anniversaries. I don't have the issue with that, but I have the issue with maybe parking.
One of the issues that comes up with commercial activity.
When you're looking at converting a hayfield into, not every farm accessory is a fish concert. I think that is an example of what it did to those fields.
Yeah, some are, right.
So I think it needs to be regulated. But somewhere along the way, we're going to have to solicit information on sizeability.
Well, that's what we say they keep kind of coming back to. But anyway,
Yeah.
it's another place for us
And
to
I wanted to understand.
address.
Thank you.
Okay, so then Ellen's brought over the working group to advise on the report back, and I expect that we will, what I would like to do, and I will do, is come look at the kind of the tier 3 things we asked them to do there and see which ones would be good. And I don't know if you got to that, Ellen, or
It's a very broad list. And so because the rest of this report is looking at different working lands, you may we may want to keep them all.
Oh, the tier 3 list.
Yeah.
Yeah.
That's, so I kept the whole list because this is about also primary agricultural soils.
Here's the list.
Oh, page 11 at the bottom, the yellow part.
Oh, that's the stakeholder group.
Yeah.
I'm talking about the things we were looking at in tier 3.
Oh.
Resources.
Oh,
How we want to include them in the study.
oh, okay. I did not know that.
You might want to make some suggestions.
We will.
Yeah.
That's what I said. I'll look at that. Yeah. Representative Chapin.
I wanted to ask about, so one of the things we heard a lot of feedback about, we heard feedback from some of the stakeholders that they didn't feel like they were as engaged or listened to. We also heard from a lot of Vermonters that they felt like their voices weren't part of the process, particularly landowners. And I saw in Act 181 something that I can't remember where it was in relationship to this working group, but I think there's a section that says this working group shall engage the voices of landowners and people affected by, I think at the time it was tier 3.
Yeah.
I guess I would propose that we pull that language in and adjust it.
Yeah. It's a list of things I want to look at to bring in.
Yeah.
Exactly. On that list. And that was when, it's on Ellen's slide that we looked at the other day.
Yeah, this was subsection C, that was subsection D. It was after that, but I guess I didn't understand.
Okay. We're just starting. Representative Tagliavini, North and Labor.
In section C, the highlighted area, Farm Bureau has been asked to be added to this group as well as for Vermont Forest Products Association.
And maybe it's the same thing that Ella was talking about, but just rural property owners, individual people. Everything listed in section C here is organizations and groups. What about just a couple of owners?
Yeah, yes. The way the language was municipalities and rural property owners in the tier 3. So yes.
So 181.
And you know, for this group to consider is yes, I agree they should be added to this. And this is an information gathering report for the legislature to then figure out how to reach out to Vermonters, which is fine to have them on here, but that's the way I'm seeing this currently.
Okay. This isn't doing the work. This is the group that's going to define how to tell us or suggest to us.
They're gonna collect the options and and then what is the next legislature? I'm trying to work within the time constraints of reality that we have right here.
I know.
Okay, page 12.
So I'm happy to tee this up a little bit.
Oh, yes.
One of the things that I feel like has actually come up over the years with Act 250 and its relationship to the legislature is kind of what we're experiencing right now. People having issues with individual project reviews, and then legislators proposing statutory changes that affect the whole state based on one issue that might have gone awry with the district coordinator or some other piece. And so, and then as we've unpacked how this has been rolled out, there's also been like, well, maybe a lack of understanding or communication between the legislature and the Land Use Review Board on legislative intent. And so I actually met with other chairs who are on other areas of jurisdiction in the legislature who have standing oversight committees, and kind of got to this idea that maybe it's time for the environment to have a standing oversight committee as a clearinghouse also to help people, when there are constituent concerns that come up, as a bridge between just making statutory changes and then addressing, maybe it's personnel issues or administrative issues, but just struck me that we should try this on as a tool so that the legislature is more actively engaged in both the land use review board, but also the Agency of Natural Resources on a more regular basis. Because the same thing can be said for that too. We're hearing about wetland stuff, we're hearing about permitting issues as just a liaison for the legislature when we're not in session. So Ellen, maybe take it from here. You've done some research how those other committees were organized and has brought us an idea.
Yes. So, so section 11 on page 12 is a brand new section that hasn't been previously discussed. And it would be adding a new chapter 32 to title 2. And so title 2 is the title on the legislature and its committees. So there are at least 5 standing oversight committees that are joint committees between the House and the Senate. And so the language establishing them is pretty boilerplate. There's a couple of things that you can customize, but most of this language I sort of just copied and inserted a couple of small changes to be specific to this. You can be a lot more specific and do a lot more customization if you'd like, but setting up a committee that meets primarily outside of the session with legislators having specific oversight of agencies is pretty boilerplate. So like this is pretty consistent with what those other committees include. But if you'd like to make changes, you can.
And just tell us what the other ones were. It was the
There is joint
legislative
justice.
justice, yeah.
So joint justice, there's also joint healthcare reform. There is joint transportation. There's joint information technology.
And joint just means.
Joint pension, yes, and then joint pension. So yes, it just means a joint between the House and the Senate.
And I mean, it's interesting. I read that you focused it on permitting. I was thinking it was more just more broad than that, but
Okay.
you can try this on.
Yeah, I wasn't sure how to.
It's good.
Okay, so creation of the committee. So there's created a joint legislative permitting oversight committee, and maybe you want to adjust that, whose membership shall be appointed each biennial session of the General Assembly. The committee shall exercise oversight over the Land Use Review Board and the Agency of Natural Resources permitting processes. And again, happy to be changing that to reflect exactly what your intent is. Composition, the committee shall be composed of 5 members, 3 members of the House who shall not be from the same party appointed by the Speaker, and 2 members from the Senate who shall not be of the same party appointed by the Committee on Committees.
Can I just ask also that there's representation from Chittenden County? Like,
Yeah, but I think you might get overruled.
well, I just don't want it all rural. I just want, I know like the state agencies will represent the urban area. I just would like, I just want to make sure that it's just not all, that there's a balance of voices on this as far as urban.
I guess I would suggest that it's got limited membership and that I would trust the speaker, and if it's is it the committees or I don't know, the Senate.
It could be the pro tem. We've done both in the past, but.
It would have geographic distribution in mind.
Okay.
Procedure. The committee shall elect a chair, vice chair, and clerk. You maybe don't have to include clerk if you don't want to. It's less in vogue lately. From among its members and shall adopt rules of procedure. The chair shall rotate biennially between the House and Senate members. The committee shall keep minutes of its meetings. A quorum shall consist of 3 members.
So the thinking we need 2 senators and 3 House members is really just because there's so few senators and we have this, we just sort of, it's our tradition, our custom and tradition to have 3 from each, but they're literally
On committees.
They're all on a million committees and sometimes they're not able to share. I did check in with some of our Senate colleagues on the Natural Resources Committee, and they're okay with this. They understand that it's only 30 of them and there are 150 of us, and we have a lot more opportunity to share leadership positions.
Right, page 13, meetings. When the General Assembly is in session, the committee shall meet at the call of the chair. The committee may meet 6 times during adjournment and may meet more often subject to approval of the Speaker of the House and the pro tem of the Senate. So you can change this. I think this is how some of them currently operate, where they meet sort of ad hoc during the session if an issue comes up, but then they have more standing meetings outside of session. You can change that or be vague. But you, in the next section, give per diems to these members. And so that's why the speaker and the pro tem are generally have to grant permission to make sure that there's money in the budget to be able to pay for legislators' time.
Do the others have that to kind of limiter on them?
Some of them do and some of them don't. So some of them do have a set limit, some of them don't.
I mean, some like most of them have it or don't have it or.
I'm sorry, I don't remember off the top of my head. I can get back to you though with information on that. Compensation, so for attendance at a meeting when the General Assembly is not in session, members are entitled to compensation and reimbursement for expenses under the per diem statute 23A. Assistance, the professional and clerical services of the joint, a joint fiscal office and the Office of Legislative Counsel shall be available. Professional, maybe it should say legal, but so joint fiscal and leg counsel will be available to the committee. And then duties. So this was again me taking just a first draft at it. So the committee shall oversee the Land Use Review Board, the rollout of the statutes amended as part of 2024 Acts and Resolve number 181, how the permitting process in Act 250 is working, and how the new board structure is working. The committee shall also oversee the Agency of Natural Resources and their permitting process. All right. Something to think about. The next section, section 12, is not changed from the Senate versions. This is the Department of Housing and Community Development's report on the discretionary review of housing. And that report is due January 15th, 2027.
I reread this. Okay. And it struck me that it's very much assuming that discretionary review is a bad thing. And I would like to fix that. And I'm looking for where it, how to reduce the negative impacts of discretionary review. Which I don't know if we already know them. It seems like they think they know them. And I'd be curious about adding something. Open that up a little to the positive aspects of discretionary review as well. Representative Chapin.
What section of law is this in? Is this in session law?
Yes.
It just seems out of place and something that they could do regardless of whether we
But it's statute.
have it in session law.
Yes.
It just doesn't,
A lot of time.
I think they're gonna do it anyway, so just saying.
Yeah.
Doesn't feel like the right group of, oh, I guess, yeah, Susan there, yeah, Just wondering if it's the right group to really look broadly at what discretionary review means and what both the benefits are and the challenges. And
Yeah. Does it mean, what are the benefits? What are the negative impacts? And why isn't it in the bill? Yeah. Yeah. Senate take testimony on this?
So you may recall that this bill originally was called an act relating to a study of the creation of model bylaws. And so this report kind of got built out of that. The original ask was a report to study how to create model bylaws. And then they've tacked a few things onto it. So yes, they did take testimony, and they kind of wedged some other things into what was originally proposed.
And Burlington has form-based code, which is what this is. Middlebury's had form-based code. There are model bylaws out there. So I guess I don't know what we're getting. This. Representative Tagliavia.
Am I hearing what you just said, that maybe we don't need section 12?
Seems like the folks who want it are gonna do it anyway, and the model codes are out there, and I don't know. Sure why we need it.
I think I agree with that. Well,
Striking that.
All right. Section 13, page 14 into 15. So this is the section that's amending the regional plan adoption and amendment process. And I have included in here, which is highlighted in yellow, the language from H 940, the miscellaneous energy bill that has it updates to the enhanced energy planning process that the House passed previously. And so section 13 is amending 24 VSA 4348. Section H 940 is also amending 4348. H 940 is on the Senate floor on Friday to concur, and so it will pass in theory soon. If you do not include this language here, it will be overridden by if this bill were to pass. So you're making changes here that conflict with changes that are being made in 940, and so there's a risk that they will. This bill would potentially override 940, undoing its changes, unless you include them here.
And this language came from where?
The Department of Public Service worked on it with the planners, and so it was in H 940 and House Energy.
But you're saying it's different from what's in 940.
Your bill, S 325, is different than 940.
And this is lining it up,
Yes.
but we could just take it out and the changes would happen in 940.
No. So when you pass two bills that amend the same statute, if they don't match, the one that's passed later in time overrides the one that's passed earlier. And so the language that's on page 15 is it's not that big of an issue, but it's, if you want to preserve this language, the language that's in subdivision B at the top of page 15 would be deleted from the statute if you do not include it in both bills.
Isn't it cheaper?
So it's just because it's this specific section. We all voted on the floor already and passed this as a body. So we're just incorporating it here so it doesn't get overridden by our bill, because it's also section 4348.
Yes.
then we mess up the energy bill that we passed.
The energy bill has this exact wording.
Yeah. So it's like not related to our bill, but if we don't include it here also,
I think we could just take this section out of our bill.
I took the whole section out.
Yeah,
oh,
I'm trying to say we could just take the whole section out. These are all kind of conforming, aren't they? These changes.
No, no, this is creating a separate process for regional plan amendments. I mean, it's definitely a policy choice. If you don't want to include it, you don't have to, but
Let's dig into the policy.
sure. So so first subsection B is clarifying that they have to 60 days prior to holding the first public meeting on the regional plan adoption. This is setting up that the next section will talk about regional plan amendment. And so currently in statute, adoption and amendment have the same process. The planners, I believe, are the ones who proposed this to say that they would like a separate process for amendments, which will basically include one fewer public hearing than an adoption would.
Be interesting. We've just been hearing about public engagement.
Seems going backwards.
So let's explore further.
And so it's adding at the top of page 15, in addition to that, they have to submit their draft plan to the board for review and comments. And if it's seeking an optional determination of energy compliance, to the Department of Public Service for review and comments related to conformance of the draft plan with 4352. So currently 4052 has a parallel process by which regional planning commissions submit their energy plan to the Department of Public Service. This would have the review happen at the same time. And then subsection C is striking out reference to an amendment, as well as in subsection D, and that is because this is just going to be the process for regional plan adoption. An amendment will be addressed further on in subsection N. Next, on page 16, again, the language data to enhance energy planning is being added. So at least 30 days prior to the first hearing, the Regional Planning Commission shall provide each of its members with written description of the changes. The Regional Planning Commission shall, if it is seeking an optional determination of energy compliance, solicit feedback on its enhanced energy plan, including consistency with 4352 and the planning standards. So again, just incorporating that process into the process that already will happen for regional plan adoption. Sections E and F also strike reference to the amendment process. On page 17, subsection H is adding again the language that's in 940. So 15 days following adoption of the plan, the RPC shall submit the plan to the Land Use Review Board for determination of compliance. And then again, adding the language from 940, the Regional Planning Commission shall also at this time, if seeking an optional determination of energy compliance, submit the plan to the Department of Public Service for review with conformance. And a summary of any comments received during the public hearings. So those are the changes from 940 that are added here. If you don't want to include them, you don't have to. And then on page 18 and 19, there are a couple of changes that are highlighted because you all were discussing last week. As proposed, this subsection N was about regional plan amendments, non-minor future land use map amendments, and tier 1B area status requests. You all discussed whether or not it should be non-minor or major, because subsection J does address minor plan amendments, which are those having to do with fewer than 10 acres. I have changed the references here to major, but you do not have to keep that. It was slightly unclear to me if you decided.
seems more straightforward unless there's something we don't know about why they wanted non-minor or non-major, or non-minor. Non-minor is very negative.
Yeah, I don't want to spend a lot of time on this. I don't think it's significant in and of itself, but I think perception can be a really big issue. It's a permit process, it's things that relate to permit processes, and I just think majors has connotation with it that might not always be. So if 10 acres is the threshold, can we just use them? I just wonder if there's just maybe a not major and minor, and then there's something else that actually has to do with the threshold. Anyway, I don't need to belabor it. I'm the only one who has that concern. I'd rather use a different word.
That's all. I thought you were also one that brought up non-minor or non-major. Or sorry, minor, non-minor.
No, I
asked about it.
So we should you're suggesting going back to non-minor?
I think it worked. It's weird. But at least it doesn't have a potential really negative association and cause confusion. I think this can cause confusion in the public around changes to land use maps where people hear or see on a bulletin or whatnot, please come and learn about this major. I just worry about how it will impact the public process.
I think that's a good point. I think you're making my.
Okay, go back to non-minor. So just remember, remind yourself
After that, yeah,
that it goes back to, because
it sounds
Because
weird.
J is minor. Just like you have to go refer back to the minor.
Right, and minor amendments, fewer than 10 acres, and they don't have to do a full update process. They don't have to go do a full update of the plan. And so I think perhaps you can just perhaps consider about in general, maybe you want to merge these two concepts, or maybe you don't, but is there a type of amendment that you want the RPC to go through a fuller process for? Are there things that they could change quickly without much formal process around it? And then other changes that should have a formal hearing process or not?
I think that's addressed in J. It tells the LERB to figure that out.
Yes. I'm just suggesting you could actually merge these two if you didn't want to have that distinction. You also don't have to.
Representative.
Yeah, I understand non-minor seems awkward and major might be too strong, so maybe it's just a different word like significant.
Why don't we have no word, just like amendments and minor?
Right. Future land use amendments. Why qualify it if it's not minor?
It's just an amendment. Or if it's fine, it's a
It's
minor.
much cleaner.
About
Minor come under those things. Would minor then be a part of that though? Like,
yeah, so it's the amendment or a minor amendment. In other words, use the qualifier only when it's small.
right? But if it's not qualified, then would amendment by itself also include minor amendments?
Oh, I see what you're saying.
Not if in statute.
Not if it's-
Be different process.
If you got a separate section J, just.
I'll be clear.
I would, if you were to ask me to do that, I would make very clear that it says not including those in J. Because otherwise I do think it would be confusing.
Which often happens in statutes.
Go back to our.
Yeah, that's right.
Okay. So you would just like. Yeah, if you could do that, that'd be great. Okay. You're gonna omit any qualifier for future land use map amendments, but make clear that we're talking about non-minor. Oh,
So the
God.
definition.
All right. So help us understand the difference between the minor amendment process and this
I get it.
non-minor. Why do we need?
So,
Minor doesn't even have a public review.
yes,
Okay.
yeah. They submit a request to the land use, review board for a minor. And then I don't think there is a public hearing. And then they don't have to, do an amendment. They can just include it in the next adoption of the regional plan. So I don't know what that looks like in practice or if any of them have done that. I presume no one has done that yet, but I think they were asking for this as part of Act 181 when they were trying to foresee what could come up with some of the boundaries with the new land use categories. And so maybe you want to just hear more about this process from them. So the next, section 14, so page 20 into 21, very small changes here. This is the statute on the land use categories for the regional plans. First, there's an incorrect typo being corrected on line 18. It's the wrong cross-reference.
18, line 15.
Page 20, line 18.
Oh. See, we're not walking through the process of amendments. Okay, okay.
Next on page 21, the sentence has been deleted that said it is the intent that every town have most towns have at least one center. That sentence is removed. And then also on page 21 and 22, walking distance has been put back in the statute. On page 22, down at the bottom of page 22, in the sentence version, it previously said the municipality has either public water or wastewater. If no public water or wastewater is available, the area must have soils that are adequate, and so it's taken out that it said public water or wastewater. Now it just says public wastewater. The rest of the statute is unchanged from the Senate version. Page 24, section 15, this is the definition of smart growth principles. It has not changed from the Senate version. And so then next, so in the section 16 is 24 VSA 4476. In the version that came over from the Senate, 4476 was proposed to be repealed. So instead of repealing it, this version would update it. And so this statute is the formal review of Regional Planning Commission decisions. So on page 26, this is an older statute that uses Regional Review Panel, which is a body that hasn't existed since at least 2010. And so the references to them doing review of regional plan work is being replaced by the Land Use Review Board. And so this is mostly for discussion purposes, I think, because some of what happened in this statute is captured by the statute we were just looking at, the regional plan review process that the Land Use Review Board now does. And so just to take a step back, previously, prior to 2010, there was a body that did review of regional plans, but then that body was eliminated. And so between 2010 until 2025, there was no body doing oversight of regional plans. And so this statute has been on the books and hasn't been operative because there was no body to do it. But there are other things in this statute that perhaps you'd want to consider before fully repealing it. So I'll read through it, and perhaps you will decide to repeal it anyways, because a lot of it is already captured, but some of it perhaps is not captured. Formal review. A request for formal review of the sufficiency of an adopted regional plan or amendment, or for formal review of the decision of a regional planning commission with respect to the confirmation of a municipal planning effort, or the decision relating to approval of a municipal plan, shall be to the Land Use Review Board created under Chapter 151. And so, as I mentioned, there used to be this body, the Regional Review Panel. A request for formal review shall be filed within 21 days of adoption of the plan or amendment or the decision. Standing. The following have standing to request formal review or become parties to formal review conducted under this section. A person owning title to property affected by a decision of the Regional Planning Commission who alleges that the decision imposes on that property unreasonable or inappropriate restrictions that significantly impair present or potential use under the particular circumstances of the case. A municipality whose planning effort is the subject of a decision by the Regional Planning Commission, and any other municipality within the region, any municipality which adjoins the region, or Regional Planning Commission which adjoins the region. So we haven't talked about this much in this committee recently, but municipalities that have an adopted planning process by which they adopt their plan and their bylaws can have that process confirmed by the Regional Planning Commission, where the Regional Planning Commission goes through their planning process to review that it meets the requirements of Chapter 117. And so this is sort of a dispute mechanism for that process also, which I don't think has happened. I think this has been a gap. If a municipality has a dispute with a Regional Planning Commission and their decision, I don't think there currently is a mechanism that addresses that other than what is in this non-operative statute. Number 3, an agency, department, or other governmental subdivision of the state owning property or an interest within a municipality listed in subdivision 2, and the Agency of Commerce and Community Development. On to page 27. Any 20 persons who by signed petition allege that the decision, if confirmed, will not be in accord with the requirements of this chapter, and who own or occupy real property located within any combination of the following. Any municipality whose planning effort is the subject of the decision by the RPC, or any municipality which adjoins a municipality whose planning effort is subject to the decision by the RPC. With respect to the sufficiency of an adopted or amended regional plan, any 20 persons who by signed petition allege that the plan or amendment is not in accord with the requirements of this chapter, and who own or occupy real property located within the area that includes the region and the municipalities that adjoin the region. The Regional Planning Commission whose plan, amendment, or decision is the subject of request for formal review. Procedure. Notice of formal review shall be sent by mail to the municipalities within the region, to the Regional Planning Commission and the Agency of Commerce and Community Development, and shall be accompanied by a statement of all reasons why the appellant believes the plan or opinion to be in error, and all issues which the appellant believes to be relevant. Within 30 days of receipt of the notice of formal review, the date for a hearing shall be set and the Land Use Review Board shall publish notice of the hearing onto page 28 in a newspaper of general circulation in the applicable region, and shall provide notice in writing of the hearing to the individuals and organizations that had requested notice from the Regional Planning Commission under 4348 relating to the adoption of the regional plan. The appellant shall pay the cost of publication. The hearing shall be held within 45 days of receipt of notice of formal review. Upon motion for good cause shown, the board may extend the date of the hearing. Within 20 days of adjournment of the hearing, the board shall issue a decision approving, conditionally approving, or disapproving the regional plan or amendment, or the opinion with respect to confirmation of the municipal planning effort, or approve the municipal plan. The board shall be governed by the provision of contested cases in 3 VSA chapter 25. Issues on formal review. With respect to formal review of the sufficiency of an adopted or amended regional plan, the board shall determine whether the plan contains the elements required by law, whether the plan is compatible with plans of adjoining regions, and whether the plan is consistent with the goals of section 4302. On to page 29. With respect to formal review of a regional planning commission decision on the confirmation of a municipal planning effort, the board shall determine whether the municipality is engaged in a continuing planning process that within a reasonable time will attain consistency with the goals established in 4302, and whether the municipality is maintaining its effort to provide local funds for municipal and regional planning purposes. With respect to formal review of Regional Planning Commission decision on the approval or disapproval of a municipal plan, the board shall determine whether the plan is consistent with the goals in 4302, whether the plan is compatible with its regional plan, and whether the plan is compatible with approved plans of other municipalities in the region. Stays. The filing of a notice of formal review shall not stay the effect of the plan or the decision of the Regional Planning Commission unless so ordered by the board. On to page 30. If notice of formal review of a decision of a Regional Planning Commission to approve or disapprove a municipal plan is filed prior to final adoption of the plan, the board shall stay formal review proceedings pending final adoption. The board, however, may proceed with formal review upon the request of the municipality whose plan is subject of the review. And finally, an appeal from a decision shall be to the Supreme Court. So you have amended 24 VSA 4348 to provide the Land Use Review Board authority to review regional plans and have them reviewed for consistency with the statute. This statute 4476 also addressed the municipal planning process review by RPCs and the municipal plan review by RPCs. And so that is a current gap in the statute, I would say. And so if you're interested in addressing who reviews the RPC's decisions and review, that's what this statute did. And it also had an appeal route to the Supreme Court. So if you repeal the statute, you will lose, I think, those two specific things, the review of regional plan review, and then the ability to appeal further to the Supreme Court.
So you couldn't appeal to the Supreme Court if we don't have this in statute? I mean, it seems like you appeal any decision of a body, like, or to the environmental court.
So in these two specific aspects of regional plans decisions, yeah, I don't think, no.
And I know it's the first time that the two members from the Land Use Review Board have seen this language, but I guess I'm curious at first read, how much are you already doing of this effort? And then for us to discuss is like, is this redundant, or do we, because presumably the Land Use Review Board is already looking at all the plans and checking them for this. this also provides an individual property owner the avenue to appeal how their land is treated in the regional board. And if we repeal it, I mean, albeit it was the regional planning commissions overseeing themselves or each other, right? And my kind of historic understanding of that it was more of almost a quality control feature of checking each other. But I hadn't really thought about the individual landowner's right to appeal the decisions or the plan.
Yeah, the board obviously has not reviewed this yet and can't like take a position on it, but you're correct in terms of the existing section under 181 allowing the board to review regional plans like that. See, it does seem to be redundant with what you have here, or what exists, I guess, under this. But the municipal side of it, we don't have that. I think that's correct.
And the individual landowner, I mean, you know, it's certainly conceivable that someone owns a piece of property and didn't know about the planning process, wasn't engaged in the planning process, or otherwise aware of it. And how do they, like, I mean, these are not land use decisions, but they are potentially affecting someone's property.
Yeah, there is a process for objectors within the process.
In your process.
In the current process that we're standing up for regional plan review.
What about an objector, though, who's outside of the formal process of regional plan review? Like if they become aware of something, you've already approved a regional plan and they come to you after, are you including that in your process that you're standing up?
I'm not sure at this point. Yeah, I can look at that though.
I think I would ask if you can kind of put this out to your board and get us some the response you're able to do as on short notice. Yeah, Brooke.
I would just, one thing that I would look at, and I will, is whether or not Rule 74, 75 might give an avenue of appeal to an individual landowner as a result of governmental action. One governs if there is a path laid out, and the other is if there is no path laid out. So not having that provision might then trigger civil rules, so that you wouldn't go to the environmental division, it would be regular civil court in the county in which the land would reside.
And you're talking about your own land use review board, Rule 74, 75.
No, this would be the rules of civil procedure.
Okay, thank you.
For going to court. And often there is an appeal route. So if the Supreme Court appeal route would be written into statute, that's what would be available to that landowner. If that was not there, the civil rules might give a path when there is not one specified in statute.
Thank you. Yeah. Okay. Others have thoughts on this? Representative Burns.
Was a regional review panel in existence? Are they meeting? Do they review these?
No, they stopped in 2010.
Yeah, they were repealed from statute. Yeah, so that's how this started, was there was a proposal.
Process.
Well, the proposal in the Senate was that this whole statute should be repealed because the body who did this work was repealed 15 years ago.
So that was an oversight to leave this section in, do you think?
It is unclear to me why it was not repealed originally.
Do you remember, or have you learned, I used to know this, but I don't, the history of why when this oversight group went away? Did we just not fund it?
I do not recall. I can get back to you. I looked into it a few years ago. I don't recall. There are members of the legislature who are still here who worked on it then, who may remember also, but I don't know.
Representative Chapin.
I guess I feel like these issues around different parties and their access to some kind of legislative judicial process seems important, and I don't want to get stuck on this. We're just sort of taking this up on, feels like the 11th hour. I don't want to lose it. So I appreciate walking through it today and just understanding. So thanks to Ledge Council for flagging this for us and for having a chance today to walk through it. I guess I wonder if we can get a little bit of feedback in a short time frame. Great. And it feels like we could ask the LURB, if the LURB is the right body, to make recommendations on this for next January if we don't feel like we can move something forward.
The question is, do we repeal it or not repeal it? Because the Senate proposal repeals it.
I guess if we're gonna repeal it and not replace it, I would propose we make a section that asks for recommendations on how to get at this and make sure there are avenues for review and appeal.
I repeal it. I'm concerned about the appeal process in general, how time consuming it is and expensive it is and how it can hold up things. So I would appeal it and, have, something put in that from the LURB.
I'm trying to think in the back of my mind somewhere, and I'm probably way off base, and I might be relating it to something else, but I was thinking the regional plans are not appealed.
They're not right now. Well, I mean, are they actually, Ellen? If this currently, this isn't repealed, but there's no body to do it. So I guess technically they're not unless what Brooke Dingledine just said would be the procedure under civil rules of procedure. That'd be the only avenue.
And that's, I think it's the last section of Title 24 actually has a statute of limitations. I don't recall off the top of my head about looking at it if it's for municipal or regional plans or both, but it allows a challenge election. No defects and pretty much it's enacted that kind of. So that would suggest there is the expectation that there can be enough people. Again, I'm not referring it to this only town.
How often a regional plan is actually appealed? Did you have something, Representative Sakowitz?
Ellen, what would happen if we just leave it alone? Is there anything, negative consequences that you would foresee? It seemed like this was brought up because it was kind of a housekeeping thing more than anything else. It's not actively causing a problem instead to keep it here at the moment. Is that right?
It has been in statute without the review panel for the last, 15, 16 years. I have been made aware that there is litigation currently about whether or not this appeal right still exists.
Litigation about whether the appeal right still exists.
Yes.
Because someone wanted to appeal and couldn't.
I believe so.
So how do we find out more about that?
I don't know. I don't know. Perhaps I can look into it.
Further thinking that if it hasn't been an active problem, but we also just heard that we don't know really why it wasn't repealed at the time that the rest of the law changed. So maybe there was a reason. So it just seems like do no harm. We leave it in until we have more information, and then we can take it out when we're sure that it's really the right thing to do.
Currently an appeal about a lack of appeals. There's currently an appeal about a lack of ability to appeal? Is that what you said? Or there's litigation?
I cannot speak confidently about what the litigation is about. I'm happy to, that's all I can say, I think, at this point.
We do appeal too.
Yeah, that's right.
Question, Madam Chair.
Yes.
Just want to clarifying on what Larry was trying to get at. Are you, when you say leave it alone, leave it in here, but with the little changes we made to enact
No, to,
land use review board as the person to deal with it?
that's a good question. No, to leave it alone in statute since,
With the non-existent review panel.
yeah.
Okay.
How long would it take the land use review board to just give us a kind of a quick read on how much of this is already covered in your process?
Let's see, I mean, officially we meet on Mondays, so we will be meeting this next Monday and we can certainly bring it up.
And I think we can also talk with our general counsel in advance to try to get teed up and then answers for this. So that she could give a recommendation to the board.
Yeah,
Like that.
that would be good. Be helpful. Thank you. Okay,
Then the next question will be, this does stay in. The land use review board is going to have to review all the regional plans, and what's the time frame on
they
that?
already do that.
They do that.
This is only if people are aggrieved. But maybe the point is what you're making is with this bog them down, potentially. I think we can ask a few questions and get back to this topic. Okay, moving on.
Page 30, section 17, this is the regional and municipal plan extension, and so now it is for any regional or municipal plan due to expire in 2026. 7 shall have its plan extended until December 31st, 2027. Section 18 does not have changes in it. This is this section that amends the definition section of the community investment program.
Yeah, and so we did hear some testimony on this today, and I think there'll be a recommendation that we want to look at for next time that I'll get you as soon as I get it. But the gist of it was be cautious in expanding areas designation without commensurate increases in funding, partly that, but also perhaps just caution around this as right now, taking it away from our historic centers. Okay.
Section 19 is amending 24 VSA 5803, which is the designation of downtown and village centers. This language also has not changed from the Senate version.
High level, remind us what it's.
It is striking reference to the regional plans, identifying these areas as eligible,
Right.
and then striking a section considered redundant. Section 20 is the eligibility for downtown and village center tax credits. That language also has not changed.
Right. Thank you, Ellen.
And the effective date is July 1 now instead of on passing.
Thank you.
Thank you.
Thank you.
All right, members. It's our work for today. I would say that, we'll be spending some time with Ellen the next coming days. So be adding time on the continued work on this.